This is your first multi-voice time writing at 140 words per minute. Your proper names are Mr. Ashland, Mr. Penn, National Trust and Title, Mr. Norman, Rockford, Salem, Ralston, Johnson City, Garfield, Ben, paragraph 3, Penn and Ashland, and Horner and Norman. I am the court.
Mr. Ashland.
Mr. Norman.
The court.
Mr. Ashland.
Mr. Norman.
And this is going to be all colloquy, and it's going to begin with me, the court. Ready? Now, gentlemen, do you have anything that you think we have not covered? You are going to make a small amendment, aren't you?
I have offered that amendment.
Yes, that will be all of your documentary evidence, will it, Mr. Ashland and Mr. Penn?
I'll say yes with this reservation that if they are allowed to go into their peril testimony, there may be other documentary evidence.
Well, assuming that they are, what other evidence will there be?
I presume counsel for the defendants will introduce the deed and also the abstract of title, may wish to introduce into evidence.
Will there be any objection to those documents on that condition?
No.
On the condition they are allowed to go into that peril.
Any depositions to take?
None that we are aware of now, unless something unforeseen happens between now and trial time.
Would you agree with that if the title comes into question in this case, that the abstract of title may be an exhibit?
I'll not make an agreement right now. Wait, I don't want to make that right now. We have found a couple of errors in there already, which we had to have cleared by National Trust and Title.
Doesn't the statute say that an abstract of title is admissible as evidence?
It's competent, yes.
Suppose I had you agree. Would you object to that?
I'll agree that it's admissible on the same condition as my other instruments were admissible. That is, if peril testimony is gone into.
Yes. Is that satisfactory, Mr. Norman?
Yes.
Now, tell me, I said something about the names, addresses, and telephone numbers in this. Of course, that has no application here. This isn't Rockford, Salem, Ralston, and Johnson City.
Or Garfield.
Or Garfield. Is this a purchase money mortgage?
It is.
Would you say so, Mr. Penn and Mr. Ashland?
Yes.
What did you say in the pretrial conference about the note being negotiated to the extent of a security and something with respect to whether the law in this state was to the effect that an assigned or negotiated note carried its security? Is that in your brief?
No, sir. That was preliminary. We have already made the amendment. I doubt if it has any applicability there.
All right.
We haven't had a ruling on that amendment.
The amendment was to the effect that the mortgage to the extent of the collateral security of interest had been assigned?
No, Your Honor. Paragraph 3 in substitution of the words "and said mortgage" for which is secured by said mortgage.
Yes.
I offer those in substitute.
Yes. In paragraph 3, then, the amendment to be made in the second line said promissory note, which was and is secured by said mortgage.
That is correct.
And that's agreeable to you, Mr. Norman?
That's right.
Would you mind putting that in for me, Ben, there?
Yes.
Now, I would like, after the transcript is written up here and you have a copy of it, there will be an original and 2 copies prepared. The original will be filed in the office of the clerk of the court here, and a copy each mailed to the firm of Penn and Ashland and to the firm of Horner and Norman. And after you receive it, I would like to have not a large, but your suggestions on the order of the pretrial conference. Just your suggestions. I won't say succinctly, I have a difficult time pronouncing the word. So let me say briefly a plan of the order that I should sign from each of you.
Furnish copies?
It might be well too. I don't want you to do a lot of writing. Don't make it extensive.
We would like to request a date for the trial of this matter.
Now, what do you say about that, Mr. Norman?
My answer is brief. This pre-trial brief, my answer will be in, and I'm not in a position at this time to agree to any definite date. I don't want to delay the matter, because if these people are going to have to own this ranch, they will have to own it, and
Torres and your Whitaker, Michelle, and Veronica support. Where's the recording? This is your second multi-voice time writing at 140 words per minute. Your proper names are Mr. Ortiz, Mr. Ma, Mr. Perez, people, fifth, DA, self-incrimination, and Mr. Whitaker. I am Ms. Torres.
The witness?
No, you're not the witness.
Oh, I'm sorry, Mr. Whitaker.
the court.
Ms. Torres.
Mr. Whitaker.
The court.
This is all colloquy. It is going to begin with Mr. Whitaker. Ready?
140.
Oh, sorry.
Yeah, me too.
Mhm.
Okay. Ready?
Oh, wait a minute. Oh, yeah.
Paused it, make sure, because that looks like,
I'm speaking to
Yeah,
it
this
looks like a
is building.
speed
He's
building.
freaking out.
Oh, you know what? No, but that's 120.
Number
Okay,
two?
maybe right
Oh,
before here.
140 number two?
Yeah.
Oh, yeah, 140
Yes.
number 2. So, did I read the names right? Yeah, I did.
Yeah,
Oh,
we're still
good job.
speaking.
Good thing you
No, I
got
was
it.
just freaking out. I was like,
Okay,
wait,
yeah,
wait.
because I do too. That happened to us the other day. Okay, so,
So it starts with the court.
okay,
Start-
so, and what did I say before that it started
It
with?
started with Mr. Whitaker,
Okay.
so.
I have a correction. It is actually going to begin with the court colloquy. Ready?
All right. Now, what exactly is the information?
This morning when I advised,
No, what is he supposed to say?
he is supposed to say something to the effect that the police told him to move. I don't know if it's this car or another car, and he is nodding his head yes.
It's another car at another date. Had asked him to move the car, told him to move the car.
So it's not relevant to this case.
No,
Then it wouldn't be coming in this case. Is that right?
I didn't say that. She's objecting to it.
I know, but this is to move another car, not this car.
Right.
Is that what we're talking about?
Why it would come in for his state of mind so that he felt that he was righteous or had the right to tell Mr. Ortiz to move the car because on a previous occasion, the police had told him to get the car out of the area and he said, I didn't have permission. They said, go ahead and move it. It's blocking the parking spot or something to that effect. And you can just move it. You don't have to have the permission of the owner. So as to his state of mind,
So this is leading to him telling your client on this occasion to move the car?
right,
Oh, I see what you are saying. Wait a second. Why do we have Mr. Ma up here then? I thought you all were complaining that
I was.
you had to have Mr. Ma appointed to represent him. So we have Mr. Ma here that came all the way up and spent all afternoon here. You people don't talk about that. What's going on here?
Let me make my record on that. I suggested perhaps Mr. Perez should have an attorney appointed based, and that is prior to knowing about this statement, based on the statements that Mr. Perez did in fact make. It's the people's position that the witness then would be also liable for, and possibly in violation of 10851 for admittedly ordering the defendant to move a car that he knew not to belong to the defendant or to anyone that he was aware of, and that based on that, it was the people's position that there's a possibility that Mr. Perez may claim the fifth on the stand. And I do not want that to happen. And since that is my position and my theory of the case, I thought that I needed to make that aware to the court.
All right, you've talked to Mr. Perez?
Yes, I have. And Your Honor, Mr. Perez should most likely have been assigned counsel before today, but I did speak to him extensively today. I reviewed the police reports and also his statements that he made to the DA investigator, and it's my advice to Mr. Perez that he should not testify, that he has an absolute right against self-incrimination, that he does not have to testify in this court or any other forum, that this is an absolute right. Now, after that advice, he still has stated to me that he would like to testify in these proceedings.
So you think he may incriminate himself in this case?
I think that's a possibility, Your Honor.
You understand this lawyer was appointed to represent you. All right, then I suppose we'll proceed in that manner, and you can cross-examine this witness extensively on this matter. And then if you need time to check it out and go out and try to find some officer, I'll give you some time.
Well, Your Honor, in light of me having the statement from the witness back in June 13th, 2001, and just to learn of this potential statement,
well, I don't know what he's going to say yet. That is the problem, see?
I understand, but I think we can take Mr. Whitaker's representation that he's going to testify that the police on a prior occasion told him that that was relevant information, that the people were.
We'll leave him here because we'll continue.